r/AskReddit. Lawyers of Reddit, what is a detail that your client failed to bring up to you that completely lost you the case? Opposing counsel, isn't it true you hit victim in the face with a brick? Client, no. Marcus hit him with the brick. I hit him in the back with a piece of wood. A buddy of mine case as a public defender. A gal was busted on drug charges, and told him she didn't have any drugs on her when they arrested her. He thought, okay, we'll use that. Turns out, she didn't have any drugs on her when they arrested her because she just sold them to an undercover cop. Little late to the party, but here goes, and obligatory not my client. Company I worked for at the time was doing due diligence before acquiring a small tech startup. The COO of the tech startup was a well-liked guy in the company, friendly and outgoing. Though we had heard rumblings that the COO was rather hands-on with the work and with female employees. Apparently there was a walkaway package proposed to the COO that would let him keep a sizable portion of his post-acquisition bonus because a young woman who worked in their sales department had filed HR complaints against the COO and obtained counsel. I sat in on the meeting with the COO and the company's retained lawyers while they grilled him about his contacts with the young woman. The COO denied ever having contact with her within the company without multiple other people present. Those people said his behavior toward her in the meetings didn't raise any flags. The COO emphatically denied having any contact with her outside of work. The lawyers asked the question a half dozen different ways and each time the COO denied any out-of-work contact. Later we meet with the woman and her lawyer with the COO not present. Her lawyer gives us a rather graphic card that came with a bouquet of flowers addressed to her from the COO. The guy had an account with a florist linked to his credit card. When the company retained lawyers confronted him, he said, "But I never had contact with her. It's not like I delivered the flowers myself." COO got terminated for cause, so no walkaway package. At her request the woman was given PTO until after the acquisition, then moved to another one of the companies under our umbrella. My house was robbed. In addition to all the stuff the thief took, he also stole a bunch of my suits and all of my neckties. I had a big collection, like 100 or so. However, the thief left fingerprints on a hard plastic box that I kept spare change in. Fast forward 3 months, the thief is caught in the act of robbing another house in the same neighborhood, same detectives on my case and this new theft. They fingerprint the guy and the fingerprints match the ones from my house. At the thief's arraignment, I see him stroll in wearing my suit and my tie. I tell the district attorney, he says there's really no way to prove it. However, the tie he chose to wear was a one-of-kind street map of San Francisco and I still had all the documentation to prove it. The district attorney's eyes widen and he informs the judge. The judge has the thief placed under arrest again for possession of stolen property. The thief's lawyer was dumbfounded. It was a nice end to a rough situation. Minor traffic cases can be the worst for this, believe it or not, because they are short and simple and oftentimes the client isn't there. So if you get blindsided by something critical, there's often no chance to consult with them to turn things around. I had a simple speeding case, 70 miles per hour in a 55. No big deal. If she does a driving improvement course, the court will usually dismiss or reduce those, since her driving record wasn't bad. When I showed up for her, I found out that she had been driving 70 up an unplowed snow lane, to get around all the others' cars traveling in the lane that had been plowed because they were driving too slow. I didn't know it was even possible to drive 70 on fresh snow. The officer stated he'd already cut her a break by not writing the ticket for reckless driving, and the judge politely agreed he didn't feel comfortable reducing it under those circumstances. When I called her up after court to confirm, she claimed she'd just forgotten to mention it. Now maybe I've lived too much of my life in the South, but that just boggles my mind as a detail you'd forget when hiring a lawyer for that incident. I would have told her in advance that hiring us was a waste of money, not to mention the hassle of taking an 8-hour class, and she should probably just go ahead and pay this one. I legitimately do that all the time during consults, give my honest assessment if the case is even worth doing, and so by omitting that detail she harmed herself for no reason. At least she took it well and didn't get defensive. Friend of mine is a defense attorney. He was representing a guy with a lengthy record for assault. Basically this guy took an AC unit and threw it at his girlfriend. My buddy tells me he was able to get a plea deal for 1 year probation, no jail time. The judge is all ready to accept the deal when he asks the defendant if he had anything he would like to say. The defendant responds, "Yeah, I don't know why they charging me with assault, I never touched her. I just threw an AC at her. This is bullshit." Judge rescinded plea deal because of defendant's attitude/lack of remorse, went to trial and got a year in jail. The idea of having an AC unit thrown at me is honestly terrifying. That he filmed his offenses for his YouTube channel. The cops didn't even know, a witness brought it up on day 3 of a trial. It was a nice quick change of plea that afternoon. So you're saying, it's just a prank, bro? Isn't a valid legal defense? Client said his ex owed him a lot of money and that she was trying to get out of paying him back by getting a protective order against him. Seemed reasonable, so I took his case. At the hearing it came out that they were never a couple, that he was sending 6 toys to her residence on a weekly basis and that she never asked for the thousands of dollars he gave her over the years. Stripper. We lost. He got laughed out of court and he learned a valuable lesson: tell your lawyer the good and the bad stuff before trial. Case as a paralegal. Negligence case. Client argued that a lack of street lights and a cyclist he couldn't see was responsible for him hitting a wire pole. Upon discovery, the first respondent's report indicated that they found the driver in the driver's seat, pants down, with porn playing on the phone. Wasn't difficult to figure out who was negligent at that point. Guy in prison hired me to request a modification of his sentence because he was doing very well, completing a lot of optional programs, no rule violations, etc. He had his family come in and pay and everything to get started. I asked the family and the client if he had requested modification before, because the law said that for his conviction, he could only request modification twice for any one sentence, regardless of if they were granted or denied. Swore up and down he'd never filed before. You can see where this is going. After spending a few hours going over records and preparing documents, a copy of the CCs, the case record basically, finally arrived. He'd personally filed for modification 6 times since he was sentenced with handwritten pleadings that were all denied. So the one he hired me for was a waste of time and would never be considered at all. There's so many. My dude in a custody battle where the opposing party claims he has a drinking problem and he denies it 1000%. Even after the real talk I have with him asking him to not hide shit from me and to be honest, we go into court and at cross-examination the opposing party provides video evidence of him finishing work, driving to an abandoned parking lot to drink a few tall boys and then going to pick up his kid from school. Every single access visit. He not only didn't tell me that, he forgot to mention that his ex's brother owns a private investigator firm. Ducking idiot. Not my client, but the son of the opposing party, and presumably the party himself, lied about being blind to make himself seem more sympathetic as a witness. We didn't know either until he took the witness box, their counsel asked him to take the oath, and he picked the card up and read it. That was the cherry on top of a series of ridiculous events. The judge dismissed the whole thing in our client's favor shortly after. I was a trainee at the time, but my boss, who was in her late 60s then, said it was the most ridiculous case she'd ever handled. I wasn't a lawyer in this role, but was a law clerk. This was a typical divorce case. This particular jury trial was about splitting assets and who would get what. It was a long drawn-out case that took about 5 days. Right before the closing arguments the attorneys wanted to talk to the judge. It seems as though a couple of days prior the couple decided to get back together, and instead of telling the judge and their lawyers, they just kept it a secret. We heard 4 days of evidence, arguments, brought in experts such as land assessors, financial planning people and the like, and they were back together. One of the attorneys asked to be dismissed from the case immediately and walked out the courtroom. The judge had to dismiss the jury, and the couple was adamant that they didn't think that them getting back together was a detail any of their attorneys needed to know. Credit card theft/fraud case. When I was a young lawyer back in the late 80s, I was trying this guy on a CC case, and the witness was the department store clerk. Before video surveillance, the state relied heavily on witness identification. As she described the customer that was purchasing the very unique clothing her store sold, I asked her how could she be so sure it was my client. She looked at my client, who was wearing the most obnoxiously yellow shirt imaginable, and said, because not only does he completely match the description I just gave you, but he's wearing the exact same shirt I sold him. The jury convicted him, and I learned that day to better prepare my clients for trial.